Well, another area that I think many people have their first contact with a law office and sometimes with a lawsuit is when they have experienced a slip and fall accident. Can be almost anywhere, sidewalk, in a building, any place, in your own home, as a matter of fact, too. So our topic today is slip and falls, and as on our face-to-face in the past, we will discuss this with attorney John Patrick Dearie. And welcome again, John.
Thank you.
So we're talking about slip and falls, and there are some common categories of slip and fall accidents. Why don't we start off by thinking about what some of them may be?
Sure. When we're talking about these types of lawsuits, which fall under the category of premises liability, there are slip and falls where someone slips, and there are trip and falls where someone is caused to trip as a result of some defect. So common causes of slip and falls are snow and ice, or a liquid that was left uncleaned, whether in an apartment building hallway or perhaps on a stairway. And some common defects that cause trip and falls would be anything from a crack in the sidewalk that causes a height differential between two adjacent sidewalk flags, or something left in the street, whatever it may be. That's typically what we see as causes for people tripping and falling.
Generally speaking, who is responsible for a condition that causes an individual to slip or to trip?
Well, that depends on where the condition that caused the slip or caused the trip was located. For example, if the condition was located in a stairway of a apartment building, it's going to be the owner of the apartment building or perhaps a maintenance company who was responsible for janitorial services within the apartment building. If we are talking about conditions on a sidewalk, which typically or can have defects that cause slip or trips and fall, it depends on the location of the defect on the sidewalk. So under New York City law, the adjacent landowner, the person or company who owns the building in front of the sidewalk that either had snow and ice that was not removed or had a sidewalk defect there, that adjacent landowner, that private person or private company is responsible to safely maintain the sidewalk that exists in front of the property that they own. The exception in New York City for conditions on sidewalks is if the sidewalk is in front of a privately owned 1, 2, or 3 family home. So if someone lives in a single family home or a 2-family home or a 3-family home in New York City, they are not legally responsible to safely maintain the sidewalk in front of their property. Rather, in the case of 1, 2, and 3 family homes, it is the city of New York that is responsible to safely maintain the sidewalk.
Actually, I think it's about 15 years now, somewhere in the early 2000s when the law changed. But basically, by contrast to what you were describing as the adjacent property owner, someone who owns an apartment residential building or an office building, as the case may be, and they have an accident or a condition in front of their property, they are now responsible. But for all of those years prior to that, it was the city of New York that was primarily responsible. I think it's very important that you make mention of the fact that 1, 2, or 3 family homes are not primarily responsible for that. And as you will recall, we fairly recently had a case exactly of that situation where it was in front of a private home. Statute of limitations comes up all of the time, and particularly in slip and fall and trip and fall accidents. So let's talk about statute of limitations.
Going back just very briefly to what you just said, I believe it was 2003 that it was New York City Administrative Code 7210 that was passed, which shifted liability for maintenance of sidewalks from the city to the adjacent landowner. But in the case of, or with respect to statute of limitations, generally for a lawsuit in which someone was injured, the statute of limitations to commence that lawsuit is 3 years. So within 3 years of the date of someone's trip and fall or slip and fall, they must commence suit by filing a summons and complaint against who they are alleging to be the responsible party for the area that had the unsafe condition which caused the person to slip and trip and fall. So the statute of limitations generally is 3 years. However, in many slip or trip and fall cases, the responsible party who is the defendant is the city of New York. So if someone trips on a pothole in a sidewalk, pedestrian crossing, or anywhere on the street, or in a New York City Housing Authority building, the statute of limitations is 90 days. So within just 90 days of the date of the accident, what's called a notice of claim must be filed with the city municipality that was responsible for that particular condition. So whether it was the New York City Housing Authority or the New York City Transit Authority or the City of New York generally, if the condition that caused someone to fall was located in an area that the city or one of its agencies was responsible for, they must be notified of someone's intent to ultimately file a lawsuit by notifying them with this pleading called the notice of claim.
There is something that follows a notice of claim if someone files it in a timely way within 90 days of the accident, and that is a 50H hearing. What is that?
A 50H hearing is it's a statutory hearing, meaning that it is 50H refers to Section 50H of the New York City Administrative Code, and a 50H hearing is just a deposition. And as many people know, if you file a lawsuit and sue someone, you are required to appear for a deposition where the attorney representing the party that you have sued as a defendant has the opportunity to ask you questions about the facts of your case, what happened that caused you to be injured, and details with respect to your medical treatment and the injuries that you are alleging that you sustained as a result of the incident. So that is what a 50H hearing is. It's just a deposition where the person who was injured and who filed the notice of claim within 90 days of the date of their accident has to appear to answer questions posed by an attorney representing whatever city agency has been sued. So whether it's the City of New York, Transit Authority, Housing Authority, whatever it may be. Again, that is required by Section 50H of the New York City Administrative Code. And once the 50H is held, which is typically within a few months of filing the notice of claim, once the 50H hearing has been held, then the person, the plaintiff who has filed this lawsuit, or is able then to officially file the lawsuit by serving the city or one of its agencies with the summons and complaint.
How important do you emphasize with clients relative to taking a picture of the defect?
It's very, very important, especially with transitory defects. So things that likely will not exist at the time of trial or at the time of depositions, or that has a likelihood to change in some way with the passage of time. So obviously that's much more applicable to things like snow and ice on the sidewalk. It's going to melt maybe, the same day that it was not removed and you slipped on it. Or if someone slips on the stairs in their New York City Housing Authority building, that liquid, that spilled liquid, whatever it is, will eventually be cleaned up. So it's always important to take a picture of the condition that caused you to fall as soon as possible, but it's most important when that condition likely will not be there in the future, and obviously that applies to things that can easily be cleaned or removed or fixed.
This is an important word as it relates to litigation generally in the personal injury field, but it seems to me it's even more important, particularly in the slip and fall area, and that's the word notice.
Yeah, so in order for someone who falls as a result of an allegedly unsafe condition, in order for that person to meet their burden required by law to show that the defendant, the party that they are suing, was negligent, did something wrong in either creating the defect or not fixing it, the person who was injured has the duty to show that the responsible party either created the condition, or they knew about it, or they should have known about it. So whether it is liquid on the stairs or crack in the sidewalk or whatever it may be that caused someone to sustain injuries as a result of that unsafe condition, generally the plaintiff must be able to show that the responsible party, whether it's the privately owned adjacent building or the city of New York, knew about that condition. They knew about that crack in the sidewalk or the liquid that you slipped on the stairs, or they should have known about it because it was a recurring condition or it was there for a long time. The caveat to that is that when the city of New York is being sued for someone who tripped on the sidewalk, for example, there is a higher burden that the injured party, the plaintiff, must show, and that is that it must be shown that the city had prior written notice of that particular defect. So whereas if someone slips on the stairway in their building and the building was negligent in safely maintaining their premises, so there were always spills, there was always liquid on this particular stairway that the building should have known about and should have at some point prior to the person's accident fixed it or changed their policy such that they had a janitor go there more frequently to mop up. Whereas in that situation, the plaintiff can successfully meet their burden to show that the building owner had notice of that condition by showing that it was a recurring condition. They may not necessarily have known about that exact spill on that exact day, but they knew that there were always spills on the stairway. The plaintiff can be successful to show that. Whereas with a condition like a crack in the sidewalk, where it is the city of New York that is responsible, you cannot show that the plaintiff cannot be successful by arguing that this crack existed in the sidewalk for 2 years or 3 years and the city should have known about it, unless the plaintiff can get and obtain through the discovery process a piece of paper that proves, that was dated before the date of the accident, that proves that the city of New York knew about that specific defect that caused the plaintiff's fall and injuries. The city of New York will eventually win on summary judgment and get the case dismissed, because under the law, under that section 7-2-210 of the administrative code that I referenced earlier, the city, in order to hold the city liable for injuries that you sustain as a result of a defect, a condition that they were responsible for, you have to show that they had prior written notice of that particular defect.
You know, when we talk about slip and fall, trip and fall, we have a tendency, or at least I do sometimes, thinking about on a sidewalk condition, stairway, maybe there was something spilled in a supermarket, someone went down the aisle and slipped. Can this also have applicability in a construction site environment?
Well, yes, it can is the answer. It depends on what exactly the cause of action is, what violations of particular sections of the New York State labor law are being alleged to have been violated. But yes, notice the principle and concept of notice that the entity responsible for maintaining certain premises knew about a condition before your accident, that's always relevant.
You mentioned earlier about snow and ice, and depending upon the winter season, but there have been many in the New York area here, there have been very heavy snow. This was, I would consider to be more of a moderate winter for that purpose. But there are a couple of conditions that are important in ice and snow cases, are there not? In terms of when the last snow occurred and the time for a property owner to clean up in front of their buildings?
Yes, so that it's the basic principle or theory is called the ongoing storm doctrine. So essentially, if it's snowing out and you slip on snow in front of someone's building, you can't hold them responsible for that because that's too high of a burden to place on the property owner. You can't expect them to, when it's snowing out, to not have any snow in front of their property. So what the law says is that property owners are responsible to remove snow and ice from the sidewalks in front of their buildings within 4 hours of the end of the snow. If the snow ends after 9 p.m., then the property owner is responsible to clear their sidewalk of snow and ice by 11 a.m. the next day. So if, for example, it stops snowing at 12 p.m. noon, by 4 p.m., the property owner has to clear their sidewalk of snow and ice. If it stops snowing at 10 p.m., by 11 a.m. the next day, the property owner has to clear the sidewalk.
Do you use inspectors to go and look at defects when someone comes with an accident, an injury that happened in Queens, Brooklyn, or wherever the case may be?
Yeah, it's very important as soon as possible to get an investigator out there who will, take high quality photographs of the defect, prepare maps showing the exact location of the defect to the adjacent intersections and things like that, which is very important because, again, especially if the city of New York is responsible, you want to and you have to be able to specifically identify the defect that caused the your client's accident, your client's trip and fall, and that is always aided if you know exactly where it is. And then in other cases, we have engineers go out to examine defects and provide their engineering report as to the fact that a particular defect, whatever it may be, a defective stairway or a defective hallway or a defective sidewalk, that pursuant to commonly accepted engineering and building principles, this particular defect would not meet those generally accepted guidelines.
Just one final point, and that is the issue of, because we have had this circumstance many times you've dealt with, and that is an individual who might not be out of immigration status, and if they happen to have a slip and fall accident, does their immigration status in any way prevent them from being able to have a lawsuit to proceed on compensation?
The answer is no. If someone is not a legal resident and they are still fully able under the law to commence a lawsuit for pain and suffering that they incur, that they suffer as a result of an accident caused by the negligence of another party. So someone's immigration status does not affect or prevent them in any way from filing a lawsuit.
I just want to end by saying that we're very proud in the firm of having these question and answer brochures. As I often say in layman's language, there are questions and then they're being answered. We also have some pictures to reflect some of the defects, particularly in the slip and fall area. These are in and more than available. We're happy to send them to anyone who may make the request. So let me just remind you about that. And conclude by saying that our sole purpose of our face-to-face discussions with attorneys is hopefully information-packed to you who may have an accident in that general category, and to get some attorneys' language and some of the things you should be thinking about as we as attorneys would think about a case that you may bring to us. So thank you very much for watching, and John, thank you very much for today.
Thank you.